Welcome back to the Friday 5 for April 28th, 2023. My name is Andrew Ayers. I'm an estate planning and business law attorney. We got offices in Edina, Minnesota and New York City. It's the last week of April, and we're going to look at 5 questions that came up in meetings with clients and prospective clients this week on topics that you might find interesting and you may have a quick question and a quick answer to. And if you want to leave a question for future episodes, I'll talk about it a little bit at the end of the video. You can also submit a question at the link in the comments. Question number 1 this week: what do I need to do after I sign my trust? So this question came up in the context of actually a probate of an estate, and what had happened was the person who died had actually done estate planning. They created a will, they created a trust, all kinds of documents that they needed. However, even though they created that trust, they never actually funded the trust, meaning no assets were put into the trust. And what had happened then is that their house has become an issue because they owned their house with other people. It wasn't just owned with a spouse, and now we have to sort out who's going to own the house and who owns what share and how people are going to be paid out. We have a financing issue with the mortgage company, and all of these things could have easily been solved if, in this case, the client had actually not only set up the trust but moved assets into the trust. It's called funding your trust, and it's a very common mistake I see where someone has either used an online website to create a trust, or they've worked with somebody and just created the trust and never taken those next steps. So you can still have a will that pours over everything you own into your trust after you're dead. However, if you've set up a trust, make sure you understand if there's certain assets you want to go into that trust, that they are funded into the trust. And it can be assets with a beneficiary designation if that's what you're looking to do. It can be, you can do homes, you can do cars, you can do bank accounts, you can do all kinds of things that are owned by the trust. But just because you intend to put them in the trust, if you never do it, that doesn't mean they will automatically end up in the trust after you're gone. You could create a bit of a nightmare and still require the probate court to come in and sort out some of your assets. And that's normally why we create a trust, to avoid that whole process. Question 2 this week: if someone calls me their niece, am I entitled to inherit from them? And this is the same situation where the person had created an estate plan, but all throughout their life they had a really close family friend. And they called this family friend their niece. They referred to her as their niece in emails and text messages. It was, just almost like an unrelated family member. And the question from my client in this case was, if I'm referred to as the niece, does that mean I get to inherit under the estate? Now, the simple answer is no if the person did not have a will. So if there's no will involved, what happens is you're called to have died intestate, meaning you died without a will. And in that case, the probate court's job is to gather up all of your assets and determine who's entitled to inherit under your local law. And the inheritance laws in most states are going to be tied to actual relations of family, not just somebody you referred to as your niece or your uncle or your aunt or whatever. If they're not actually related to you, they likely will not be able to inherit under your local intestate law. Now, in this case, we actually had an estate plan. Now, in that case, if you're the niece and you're named in the will as the niece, or I'm specifically giving gifts to this niece, even if you're not the niece, then yes, you are entitled to inherit from their estate. But that's because there's a specific will or a trust that says you inherit. So you don't have to limit your will to inheritance of just family members. That's how you can use your will to give money to charities and other family friends. But if they die without a will and you're not technically related to them, chances are under your local law you will not be inheriting it from them. Question 3 this week: can I buy my grandparents' house from their trust? So this was an interesting situation where the client's grandparents had actually been dead for a while, and their house was just sitting there empty, and he was ready to start a family and thought the house would be a great place to live, but he wasn't sure what the next steps were. He said, it's my grandparents' house, it's owned by a trust, it's just sitting there, we're not sure what to do, what do I do next? So in this case, because the house is in the trust, what he needs to do is contact the trustee for the trust and find out if the trust is willing to sell the house to him. And the trust can decide whether or not to sell the house to him and for what price. So he may end up getting a discount because the trustee may say, you know what, my clients or the people who made the trust, the grantees or the grantors, left this property to the trust with directions that it should stay in the family somehow. And maybe this grandson is now the first one to show up and say, I would like to buy it, and they want to keep it in the family, and that's an easy way to do it, and he might get a discount. The other side of it is, of course, the grandson may say, I want the house, and then other grandchildren or children or cousins or whoever may also pop up and say, we'd like to buy the house. And then the role of the trustee in that case is to sort out what's best for the trust, to look at the terms of the trust, and then determine who to sell the property to. Assuming there was no trust and it's just left in the estate, then your personal representative under the will, or the personal representative or executor appointed by the court, would be the person that this client would have to reach out to find out if they're able to buy the house from the estate. Question 4 this week: is a non-compete provision in my employment agreement enforceable? And the quick answer to this is maybe. Depends, first of all, where you are. So you have to look at your local state laws and see what does your local state say about the enforceability of non-compete agreements. A lot of states view them very negatively and don't enforce them. Other states will enforce them to a certain point. In this case, the two parts of the provision were a duration, so in this case I think it was 2 years, and then a geographic scope, meaning within 50 miles. Now, this particular client has a rather specialized knowledge, and a restriction of 2 years and 50 miles would really inhibit her ability to find a job in the future, so chances are her state would say that it will not be enforceable. And of course, the flip side of this is, if you've paid attention to the news, the FTC has been proposing a ban on non-compete agreements going forward. So you may find actually in the future that you're no longer given a non-compete agreement when you sign up for a new job, or when you start working for someone else, or if you get a big promotion at work. So it used to be kind of a point of pride for my clients. So I finally made it. I'm high enough in the company that I've got to go talk to Andrew and look at my non-compete agreement. Well, the FTC is actually rather anti-non-compete agreement these days, and so you may find shortly that we no longer even use those in our agreements. Question 5 this week: do I have to send a letter if I'm terminating a contract? Now, this is going to be a very fact-specific question, and the place you have to look is in your contract and look for a provision that says notices. So there's usually a provision in the contract that says notices, that will say if a notice has to be sent to one party, it goes to this person at this address. If it's sent to the other party, it's sent to this person at this address. And in the case of a termination of the contract, the termination clause will often say that you have to give a notice of termination within a certain amount of time, 10 days, 5 days, 30 days, whatever the time period is, and give notice by the method specified in the notices provision. It may say that you have to send it by personal mail, certified mail first class, email can be fine, messengers, faxes. There's all kinds of different ways. And when you're drafting your contract, you can make sure that you understand that notice provision and understand how those notices would need to be sent between the parties. So there's not really a general rule on if you have to send a letter or not. It's going to depend on your contract. However, most contracts I read do have a provision that specifies, called notices, that specifies how things are to be sent and where they're sent and what the timing should be. So those are our 5 questions for April 28th, 2023. The weather is slowly warming up here in Minnesota. I'm hoping we're going to see spring next week. May is around the corner and the end of the school year is approaching fast. If you like this video, I'd love it if you hit the like and thumbs up button below. If you'd like to subscribe, you can go over to the YouTube channel or go to Ayerslaw TV and hit the subscribe button. And wherever you are, I hope you have a wonderful weekend, and I will see you next week.